My name is Tom Donnelly. I am an associate judge in the Circuit Court of Cook County assigned to the First Municipal Division. Well, I hear primarily jury cases in car accident cases. But I also am sometimes assigned out to do the criminal branch courts, to do eviction calls, and to do collection cases on our 11th floor. That's the bulk of my time is juries for bodily injury cases or eviction cases or contract disputes. You're first assembled on the 17th floor, where you wait in this big, large room, and you wait to be summoned in a panel. And so a panel is usually a group of either 18 or 36 that are brought down to a courtroom for jury selection. And all 36, if it's a 12-person jury, or sometimes 72, we have some larger panels, are brought into the courtroom. And the judge explains sort of what things are going to happen that day and the process of jury selection. And in my courtroom, we question the venire, the large group, in panels of 12. So 12 people are seated in the nice, soft, cushy chairs of the jury box, and we ask them to introduce themselves to the parties, and then the lawyers get a chance to question them to see if there's anything that might prevent them from being fair and impartial in this particular case. Well, if you are a orthopedic surgeon and you're called to jury duty, and the main expert for the plaintiff is going to be an orthopedic surgeon, the plaintiff's lawyers may want to use what we call a peremptory challenge to remove you from the jury because you might identify too much with that witness who is for one side or the other. In the municipal division, our trials are 1 to 2 days on average in terms of jury trial. That includes selection and the whole trial and deliberation. So they're very short. I've had a 9-hour deliberation on a 2-hour trial. It's always, sometimes the lawyers will say, what's taking them so long? One of the great things about our jury trial system is you have the perspectives of 12 different people, their various experiences in life. And when they get back to deliberate, some of them may strongly have an alliance with one side or the other. And the other jurors have to explain their experiences and how those 1 or 2 perspectives may not be correct. So there's a persuasion process that goes into the deliberation, and that's where we get our fairness, because if the majority jurors are able to explain the case well enough to those 2 minority or 1 minority jury in terms of the vote, we know it's a fair decision because there are justifiable, acceptable reasons for going the other way that will persuade the whole jury to vote a particular way. And that's one of the great things about a unanimous verdict system. In fact, because my trials are so short, I don't even ask the question of whether they're able to serve. I wait for people to affirmatively come forward with reasons. What things are very good reasons are, I have plane tickets, non-refundable plane tickets tomorrow to go to Buenos Aires. I'm being operated upon Wednesday, and this trial is expected to last through Wednesday. Those are good reasons. Otherwise, with short trials, there's no real other valid excuses. I try not to select alternates because it's really a bad experience at the end of the trial to excuse the alternates and saying, you sat through this whole trial, heard all of the evidence, and now you're not going to get a role in deciding it. So I'd rather just pick a group and rely on them to come back. And if the trial is short enough, it's not a real hardship on folks. Well, witnesses generally sit outside the courtroom while the trial is going on, unless they're a party, meaning they're either the plaintiff or defendant. And so there may be a great period of waiting where they're waiting for other witnesses to finish with their testimony. And sometimes events will make the scheduling difficult for a witness, and that's something we try to avoid by coordinating how long witnesses' testimony is going to be and only getting the other witnesses when we know reasonably witnesses A, B, and C are going to be finished, get D in place. But I know one of the bad experiences for witnesses is the degree they have to wait in order to accommodate the other testimony, how long a cross-examination is going to be. If the witness goes on in direct, it's only 20 minutes, but there's an hour of cross-examination. Well, then they may have been waiting for 40 or 60 minutes just to testify. So that's one of the things they can expect. When they do go into the courtroom to testify, they'll come right up into the well of the court, go up onto the witness stand, be sworn to tell the truth, and will take breaks sometimes during their testimony, but during their breaks, they're not allowed to talk with anyone about their testimony. And that sometimes surprises people. They think if they're a witness for a particular side, they think they're going to be able to talk to the lawyer about certain areas of questioning that have been raised by the other side. They can't do that. So that's what they can expect when they're testifying. Well, one thing that's very important to people is that there are breaks. And for juries, this is very important. So during jury trials, break every hour, so they have a washroom break. And we also, if we're in testimony, we end every day at 4:30. So they aren't staying, hearing testimony into the evening hours because they're just too tired to hear anymore. So we try to take a good long lunch break. I try to give them at least an hour for lunch. And as I said, a break every hour so they keep their interest level up.